Let's go on the record. The time is 1 p.m. This is a continued hearing for Deschutes County file number 247-25553-PADU. My name is Tommy Brooks, and I am the hearings officer in this matter. As usual, before we turn to the substance of the hearing, I'm going to turn things over to Ms. House to describe how the participation process will work.
Great. Good afternoon. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. I have a short PowerPoint that I'm going to pull up here in a second. But I'll begin today by going over the format of the hearing and how anyone interested in testifying can testify. I'm going to pause just a second because I do have a PowerPoint that needs to be pulled up. There we go. And first, again, I'll provide information on how to participate in today's hearing. I'll then present a brief staff report. Then we'll move on to the testimony portion of the hearing. The applicant will testify first, and we'll have 30 minutes. Then persons in support will have 3 minutes, and then anyone in opposition will be afforded 3 minutes. The applicant will have 10 minutes for rebuttal testimony, and staff can provide any closing comments after that. And I will note that the hearings officer book, you can modify those time limits if you'd like. So today's hearing is a hybrid hearing with both in-person and remote participation allowed. Anyone testifying, please provide your first and last name as well as your mailing address before beginning your testimony. For anyone in person, Hearings Officer Brooks will call you up here to the table. Please make sure you're seated at the table so the microphone can pick up your audio so it can be recorded and heard by anyone attending remotely. And if you haven't already, there's a sign-in sheet on the table over there. Can you please make sure you've added your contact information if you're in person? For remote participants, you need to be logged in using Zoom in order to testify. Hearings Officer Brooke will request anyone attending remotely to use the raised hand feature to notify him that you would like to testify. On a computer or smartphone, you press the raise hand button, but if you'd called in, you need to dial *9. In addition to oral testimony, you can submit written testimony at today's hearing. If you're in person, please hand that to me. If you're remote, please email that to me at caroline.house@deschutes.org. Hearings Officer Brooks and Carol and myself are responsible for an orderly and respectful hearing. Anyone being disruptive may be asked to leave. I'm going to pause now and ask if there are any objections to the hearing format described. Are there any raised hands online? Okay, that makes it easy. All right, so I'll turn it over to Hearings Officer Brooks for his hearing instructions.
All right, thank you. And as just described, we're following the hearing procedure that's set forth in the county's code, and I will definitely provide sufficient opportunity for everyone to participate, although it seems like the participation today might be minimal. As I noted earlier, this is a continuation of the hearing in this matter from October 30th of this year. At that time, I simply opened the hearing and then acted on the applicant's request to continue the hearing. So essentially this afternoon, we are starting at the beginning, and we'll just go in the order that Ms. House described. This application is being considered through a quasi-judicial process. As such, I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant portions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to the hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are available directly from staff upon request. It is important that you direct all of your testimony to the standards and to the applicable criteria. If you believe a criterion applies that was not listed, you may address that unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address that in my decision. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again with enough detail that allows me to respond to the issue in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter, and in that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I am not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated briefly with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. Um, I think just to clarify, it sounds like there were no participants online, and then we don't have anybody signed up other than the applicant, or we do?
No, I believe everybody is with.
Okay. So I don't, we'll just stick with the normal timelines as needed. But before we begin the substance of the hearing, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? Right, hearing none, we'll go back to you, Ms. House, to deliver the staff report.
So just a kind of basic locational information. So the subject property is located at 65720 Mariposa Lane. And this property is just northwest of Tumalo, about 3 miles northwest. And on the property today, there's an existing single unit dwelling that's about 3,400 square feet, as well as an approved structure that was identified as a garden shed. I think it's identified as a shop on their current plan. And just to restate, the applicant's proposal is for a accessory dwelling unit, and this is a rendering that they provided in their application materials. So just to kind of outline, I want to, because I think this is a key part of the review, is kind of understanding what the structure includes or what it is definitionally under the Deschutes County Code. So on the screen here, I've identified the different uses on their first floor plan, and I'll show the second floor plan here in a second. But the structure includes a dwelling unit, a half bath, a shop storage room, understairs storage, a shop, 2 garages, a lean-to covered area on the north part of the structure, or at least the north part of the floor plan if that's oriented in a north orientation, a covered shop entrance, a covered ADU entrance, as well as a covered ADU patio. And the second floor of the structure also has a storage room, and it also has a full bath, a covered balcony, and additional attic space. Spaces are identified in this particular floor plan. So in total, the proposed structure includes 7,680 square feet of floor area, as well as 2,247 square feet of exterior covered areas. So the staff report was written by one of my colleagues, Jacob Ripper. He accepted a role outside of the county, so this project has been reassigned to me. So he identified some issue areas in the staff report that he wrote a little over a month ago now. But for the hearing, I just wanted to identify 2 additional key interpretive questions. The first is the proposed structure an accessory dwelling unit? And if yes, does the accessory dwelling unit comply with the 900 square foot usable floor area limit as defined in Deschutes County Code? So record materials are all published on the website listed here on the screen. This is included in all the notices. There's one item that was received today at 12:30 that I've not had a chance to upload. I believe it's the CCNRs for the subdivision that this property is located in. But other than that, to my knowledge, everything has been uploaded to the record and that's current, minus that one document. And with that, that's everything I had prepared for my staff report today, but I'm available for questions from the hearings officer.
Okay. I do not have any questions for staff at the moment. So we'll have the applicant come up for their presentation.
Good afternoon, Christopher Koback, Koback, 937 Northwest Newport, Suite 220, Bend 97703. I'm a land use attorney in town and I represent the applicant, Pam and Rick Rogers, and they're seated to my right. I want a little introduction about what this case is about and what it's not about. You know, based on my involvement, and I came in a little late, as the hearings officer may have recalled, my clients asked for a continuance to get legal counsel. in November. I don't think this is really about my clients or their proposal based on my information from staff. I don't think it's really about anything on their property. What really this is about is staff has identified some concerns with ADUs in an existing building that has other space that could be an opportunity, I suppose, for somebody to, quote, game the system and come in and expand an ADU beyond 900 usable square feet. And that's, I'm not here to say that's not a legitimate concern. You know, staff has a tough job. They have to enforce the regulations in the county. I'm sure they have seen, and I've seen it because people have come to me when they get turned in, where people have done stuff similar to that. And so I can appreciate that staff has these concerns and they're legitimate concerns. What I can't appreciate is, in this case, making my clients go through this process as an example to get what staff wants. Staff wants clarity from the board. That was told to me. They want this to go up to the board so the board can clarify some things that went into the code. For example, I don't think the code is clear and objective on a lot of stuff. What can be part of an ADU? There's no restriction in the code on an ADU being part of another building. There's none. Now, I think staff would like one, but there is no express prohibition in state law or the county code. And in fact, an example would be you can have an ADU on a lower level of your house. Does that make the whole house part of the 900 square feet? That's kind of where staff's going with this. So there's no prohibition. And there's really no explanation on whether if you have an ADU in another building and there's space totally unrelated to that ADU, and I'm going to give you some evidence of that here, how do you account for that space? So those are the issues I think staff's grappling with, and again, legitimate issues. But there's a process that I think is a lot better than making these people go through the cost and the time and the agony of this quasi-judicial hearing. Get the board to reopen it. Say, we've had issues come up since you adopted these regulations. Let's initiate a legislative fix to this. Give us the clarity that we desire and need to do our jobs. That, I think, is the way to go, not to put the Rogers through this kind of an expense to get to the same, hopefully get to the same spot. So that's the introduction on the process. What I want to talk a little bit about, and this is the fun part for me, is what the Rogers proposal really is they're going to testify later. They have no plans to game the system or add space to this ADU. Rick and Pam Rogers, they live in Oregon City now. They bought this property based on a friend saying, and she's here, saying, this house is coming for sale. It's a great house. You ought to buy it. They bought it for a vacation house. And they love Central Oregon. So they want to move here. And Rick, as I've said in my letter, he's a car enthusiast. He's a car nut. He doesn't just collect cars. He fixes cars. He restores cars. And he's got a great facility in Oregon City. He's got 2 garages totaling about 6,000 square feet. The big one is his big garage. And I'm going to show you some pictures of that. Are they up? Can you put my pictures up? Okay. Is that number 1? Okay. This is one picture of a portion of Rick's garage. This isn't the best picture. I don't know why I put that one up there. This is Rick's workshop. This is separate from the big part of his main garage. This is where he actually keeps all his equipment. He's got solvents and compounds, and this is kind of where the work, a lot of the work gets done. This is way out of whack. I'm going to come back to that one. This is the second building. We don't want that. We don't want that. They didn't come in the right order. That's my fault. No, we started way late. That's the problem. Wait a minute. What disc are you using? Because I have 22 pictures and there's only 8 of them up there.
I asked when you got here, it was the same ones that you emailed me, so it sounds like it was not just images.
Well, I sent you 2 emails. Did you get both? I had to split them up.
I only got 1 email.
Oh, technology. Let's pull mine up if we can, because I have all 22 on one PDF. Did you get it back? I don't think so. Oh, that's number one. So that's Rick's garage, the one I call 1.0. That's the main part where he kind of shows off his cars and keeps them out of the weather. There's a pic that's from the outside looking, and that's what we call the main garage in Oregon City. There's some more of his cars. There's that 67 Camaro in the background, one of the most coveted collector cars you can get. And there's all his memorabilia in there. And so this is what he's got in Oregon City. He's got a little loft that goes up there on the right. You can see it better there. There's some more of his cars and his memorabilia. And that's the outside. See the architectural design. It's got dormers, fits in with the neighborhood. That's his loft in Oregon City where he stores a bunch of stuff, car parts and miscellaneous stuff. And you can see that's all conditioned space. It's got a furnace. Got to keep these little babies warm. There's some more memorabilia. That's more of another workshop that he's got in Oregon City where he does, the restoration work and the dent repair, all that kind of stuff. Now we're back at where we were with one of his classic neon Firestone signs. You don't find those anymore. Now this is part of the lower shop. So they have the 60 by 40 shop that I explained in my letter. That's where kind of the stuff non-car related goes, the tractor, here they're going to have snowplow. I told them that. And so this is the lower garage that they call the lower garage. It's more of the utilitarian garage. And so this is the inspiration for the new garage. This is in their neighborhood. This is a garage. And the point I'm going to make about this is, garages take a lot of different forms. There's some really nice garages in Oregon, particularly Bend. This is one of them. And this is his neighbor. That's his garage. And so that's kind of getting us to Rick's Garage 2.0, which is what he designed here. What he designed is consolidating those two garages. So he's going to get a little bit more. He's going up to 7,000 square feet. He's got about 6 something in Oregon City. And it's going to have the same basic components. He's got on the east end, right? Mm-hmm. The east end, he's got the garage area where it's really the working garage. And you can see that on the plans that we submitted and that staff has. And in the center, he's got the same showroom, only it's going to be a little bigger, a little nicer. I mean, there's no reason to do this if you're not going to improve, because to go from 1.0 to 2.0 is usually an improvement. And it's going to be nice space for his cars and his memorabilia. And one of the things I said in my letter, which is true, Rick's philosophy is there's no reason to collect these cars if I can't show them off, right? And so he'll have friends and family over to see his cars in his showroom, place to sit, still a garage. Then on the west end is another little shop area, which is where the tractor is going to go and the snow equipment and all of that stuff. That's basically just moving what they had down in Oregon City in that small shop area, garage area, up into the same building. They got 10 acres. Pam and Rick do all of their own yard work. They've got tractors, ride-along tractors. They've got a regular tractor. They've got now snow equipment, ATVs for hauling stuff. That's where that stuff's going to be. And then there's the ADU. Now, this is really just an afterthought for them, but it made sense because their family's growing. I told you they got 2 daughters that live out of Oregon. Pam's parents live in the Valley. They've got friends from 30 years in Oregon City that live in the Valley that come visit. So what they thought is, as long as it's available, let's put an ADU in that corner so we'll have overflow for people. Now, the ADU is 9,000 square feet of usable floor area. It's got a little patio outside that you can access, separate entrance, totally isolated from the garage. And that's its purpose. Now, Rick also has the loft, which I think is one of the reasons staff raised most of their concern here. There's a loft, the storage area, that's going to, in the future, potentially be used for multiple things. Like his neighbor Billy's got a card table. Other people have other things in their garage areas. Doesn't make them not a garage, but they're accoutrements. And so Pam and Rick are thinking now that it's going to be cold here in the winter, they're going to put some exercise equipment up there. They put a deck on it, and I explained that deck is really to support their main house. I've got a picture here this is the, did I get the view? The view was on the last one. Oh, where is it? Oh, it's not on this. It didn't make it on this one. Well, on the set that Ms. House had up there, you saw the view of the mountains. The deck faces that. So they added a deck off of the garage, which, you know, now is only accessible internal through the garage. But the plan in the future is to get it permitted to have some external staircase. They're going to have some engineering work. And that'll be where they go enjoy the sunset in the evening, particularly. And then they added the bathroom up in the loft area. Because they're going to be using it. They're going to have friends over to enjoy the cars. The loft will be open to the lower showroom, so you'll be able to be in the loft and see the cars. That's their vision anyway. And so they'll have this multi-purpose area up there, clearly part of the garage, and they're going to use it to enjoy the garage. It's not living space. They're going to testify to that. It's not their intention, never was their intention. So that brings us kind of to some of the issues I think that you're going to have to decide is, or the board eventually is, you know, what are the rules on this ADU? So as I said, an ADU is defined by state law and the county code as a residential structure. And it's independent of the other structure. And there's nothing that says, in the text anyway, says you can't have it as part of another building. And in fact, you know, I gave you for context that definition of floor area, which specifically says it's the area within walls in a building or a portion of a building. So I think that also supports the conclusion that you can have a single building in this context with multiple structures. You can have, in this case, the ADU is a residential structure within that building. It's specifically defined by state law. And you can have other areas in that, there are garage areas. Separate structure. They're accessory to the house. They're totally separate from the ADU. And so when you read the code, at least the way I read it, there is nothing in the code that says in a clear and objective manner what space you can and cannot have in that separate building. Nothing defines whether you can include this separate space as part of the 900 square feet or not. The only thing the code allows you to look at is what's on the plan. That's the clear and objective test. What is shown on the plan? And in this case, the only thing you could conclude is everything outside of that 900 square feet in the porch, that's all the garage. Now, I do think there's another way to look at that, and I put it in my letter. So if you were to indulge in saying, well, let's take a little bit of a subjective view of this. You say, you have to look at what space is part of the ADU and what is not. Because the way I read it is an ADU can have more than 900 square feet. An ADU is defined as the ADU and inclusive of garages, porches, I think carports, other areas, decks. So an ADU can be bigger than 900 square feet. The 900 square feet comes in and that you can only have 900 usable square feet, but the county code and the board in their deliberations that staff cited to decided that you could have an ADU with 900 square feet of usable area and an unlimited amount of other stuff area. No limit. The board decided not to put any limit on it. Now, if you were to go down this subjective analysis and say, okay, what counts towards the 900 square feet and what doesn't? The first question you have to ask is it part of the ADU? And to answer that question, I think you have to do a functionality assessment. How does that space relate to and function with respect to the ADU? Is that space part of, does it support the ADU? Because that's what an accessory is. You would have to say that space outside of the 900 square feet is part of the ADU because it's accessory to it. It supports the ADU. If the space has absolutely no relationship to the ADU, it's not even part of the ADU. It's a separate accessory area, a separate accessory structure, separate from that residential ADU structure that state law defines. And then now let's apply that in this case. How does any of the garage area on Rick's plans and Pam's plans, how does it relate to or support the ADU? It doesn't. It's got total different functional use. The showroom is going to have cars in it. Nobody's going to live in it. Even the loft has no relationship to the ADU. The only relationship whatsoever would be, and I explain this, when you run plumbing, you put the bathroom in the same wall. You tend to save money. But other than sharing a wall, that space is totally independent of the ADU. You can't get to it from the ADU. It doesn't function with the ADU. It's there as part of the garage. It's going to have car parts in most of it, some exercise equipment, maybe a card table, maybe a ping pong table. It's part of an accessory to the main dwelling. And so I think you start by, is this space even part of the ADU? I don't think it is. But even if you went down the path and said, well, maybe that space, because it's in the same building, maybe it's part of the ADU. Well, it doesn't count towards the 900 square feet because it's a garage. The code language is very clear that when you're counting the 900 square feet, it is exclusive of garages, carports, decks, porches. So even if you were to conclude that I've got to consider this whole thing as part of the ADU, how can you say, well, that space counts towards the 900 square feet when clearly, based on what you've just seen, it's all a garage. It's a garage no different than any other garage, not any other, but many other garages in the area. And so even under staff's analysis, what I think their analysis is, this is all, you have to look at this all holistically. All of that extra space is unlimited garage space that can be there. And I don't think staff addressed that yet. And maybe we'll hear from them on this. So that's kind of how we think this ADU checks all the clear and objective boxes. And I do want to mention that the ORS 197A 400 was recently amended, and now it applies to housing in any rural exception area. This is in a RREA exception area. So the clear and objective standards apply to this. So to say that my clients cannot have an ADU, the county is going to have to point to some clear and objective standards that say they cannot have this unrelated garage space next to an ADU. And I didn't find it, and I don't think you're going to find it. It's just not there. What staff is basing this on is their subjective concerns, again, about what people may or may not do in the future. Again, there's other ways to get at that. One, go to the board and get this clarified through the legislative process, put some conditions on that would, and they have it. There's all kinds of conditions that people sign or covenants people sign in farmland. And for example, you have to show to get a farm dwelling $80,000 of annual income over a certain period of time. Once you get your permit, county doesn't have any way to verify it. They don't even double check. So that's another example. Is you can put conditions on. It's an enforcement issue, but the county deals with it in other contexts all the time. They decide from a policy standpoint, how are we going to look into this, or are we going to look into it? Those are all policy issues that need to be decided in a separate process by the board. They don't need to be decided in this case. And then the last thing I want to say in our case in chief is, because this is a housing application, I do think 197522 applies. That Icon case, I think, is pretty clear. It applies to any application for housing and needed housing. And if you listen to the board, one of the reasons they allowed ADUs in rural exception areas is it's another form of needed housing. So that statute also applies. And what that means under the Icon case is, before the county makes a final decision that would deny this because they find it inconsistent with some comp plan or regulation, we have to have an opportunity to modify the proposal or propose conditions to make it consistent. And so we want to invoke that statutory right now. And then before I forget, we are going to ask for an open record period. I got some stuff from Ms. House last night, and then we just learned this morning that the property next door had an ADU in a shop building approved without a hearing. And so we want to give you that decision and kind of explain how we think it supports our interpretation of the code. So we may have some other stuff, but that's what we're going to put in. So I wanted to ask Billy Schilling to come up and talk to you a little bit, because there's been this concern about, well, a loft, it's not just for storage because it has a dormer. Well, the dormer is there for a good reason. Ms. Schilling, is the president of the HOA, will tell you, and that's why I gave you the CC&R. So Billy, could you move up and give her chair? got to say your name and address.
Hi, I'm Billy Schilling, 65725 Mariposa Lane.
And can you tell the hearings officer a little bit about the CCNRs and their role and how they apply to buildings in your community, including garages?
Yeah, we're a small HOA, 14 lots. There's 13 homes now. Values anywhere from 3 to 10 million. One just went on the market for 9.8. The CCNRs are clear on any outbuildings, whether the shop you saw that was mine, has to match and have integrity and keep the value of the neighborhood up. So my shop had, for our CCNRs, had to match the exterior of my home exactly. Same cedar siding, same rock, same timber frame. Not to sound bad, but just a four-walled building will get turned down in our neighborhood every time by the art committee. It's got to have the integrity and keep the value of the rest of the homes. So that's why when they first showed us a little four-wall thing, we said no.
Okay, thank you.
Thank you.
And then Pam and Rick, I want to have the Rogers just firsthand testify for you, hearings officer Brooke. So yeah, really, it's very clear on the record that they are not the people that staff is concerned about. So Pam and Rick, would you tell a hearings officer what your intention is for using the space outside of the ADU?
My name's Pam Rogers. My mailing address is 15488 South Morrell Drive in Oregon City. We added the ADU because we have grandchildren now. And our house is just not big enough with people coming over all the time. But basically, the ADU is for my parents who live in the valley that come and visit, as well as our children and grandchildren. And we have no intentions of ever using the loft area as a livable space.
Rick?
No.
Name and address.
Rick Rogers of 15488 South Morrell Drive, Oregon City. Yeah, we're just I need a place for all the cars and all my stuff. I mean, the pictures don't do it justice. I have a lot of stuff. And that one car you see is the first car I ever bought when I was 14, and I still have it. So I have stuff. And yeah, it's just an ADU for the kids. Our one daughter's just come out of Germany, and we didn't see her very often because she's in the military. And we thought, well, this would be a great thing. Now she's in the States, so things may change a bit, but it just, her parents, the kids, now we have grandkids, we have one more coming, so we really want to put an ADU out there so that they have their own space.
And tell me, what's the loft plan?
Well, a lot of it's going to be car parts. I'm not going to pile car parts up in the main showroom piece because this showroom, when we're done, is going to be a lot nicer than the other one. The other one seems to get cluttered because I don't have space for all the other stuff. So in the end, I'm going to have I got a lot of racks and car parts and stuff for the cars. And a lot of that'll be up there. And as they mentioned, we're probably going to have a seating area. I don't know. The kids will probably play up there when they're a little older. And it's going to be open to the cars, which is what our neighbors did. They've got a loft and it's open to their cars so you can see them. And it's turned out real nice. So I think we're going to do that.
And do you have any intention ever of using that for living space?
No.
Well, that's what we have for now. We'll wait to see what staff or anybody else has to say and come back. If you have questions.
Yeah, I think because we don't have anyone else sign up to testify, I can just go ahead and ask you my questions now. And most of this is just so I can kind of flesh out the contours of your arguments and make sure I get the issues teed up right. The first one, though, before we get to sort of the substantive one, is just kind of a procedural matter. I don't think you're saying this, but you just kind of mentioned there's a different process maybe staff could go through. I just want to make sure you're not objecting to this quasi-judicial process and that we are, I don't want to, I want to know if I have to address an objection.
No. I've been doing this a long time in Deschutes County. They have the right under their code to elevate matters. It was more of a editorial that I don't think this is the case.
Right.
It should have happened. I mean, the one next door got approved by the staff level. I just think there's a better process for staff to have used and to continue to use.
Fair enough. I assume that was your intent,
Yes,
but I just
yeah.
want to make sure. The, you know, I get the tricky part of this where it's basically two different uses in the same structure. And we're trying to thread the needle to show how both of them are provable. Can you, I guess, it sounds like your approach is one, you've created a physical barrier between the two, and then two, you mentioned sort of a functional test, and that the garage components are related just to the garage, not to the ADU. But I also heard you say that ADUs can have garages. So can you help me put a little bit more daylight between like the functionality and why the garage components really have nothing to do with the ADU?
Yeah, this gets to staff asked two questions. One is, would that, what they call additional or extra space, be accessory to the main dwelling? Or would it be accessory to the ADU? And they didn't really explain what that second one meant, but I'll tell you what I think it meant. But as to the first one, is that space accessory to the main dwelling? Well, that's where you get to my functionality test, is you look at how does that space outside of the 900 square foot designated ADU with the porch, how does it function and what does it support? Does it relate in any way and support the ADU? No, it is accessory to and subordinate to the main dwelling. You're allowed to have, there's no, and there's no definition of garage, and there's certainly no limit on the number of garages. It's, whatever the county will allow you to have on your site. And so they can have multiple garages that all are subordinate to, accessory to, and support the main dwelling. And that's what this is, clearly, as Rick and Pam explained to you, is this is their passion. They need it. It's not something they just want. They can't move here with their cars without doing this. So all of the space that we described and Rick just testified to really shouldn't be considered part of the ADU at all. It's a separate accessory. And staff said this in their report. This is important. If you took all of those uses, all of that space, dormer, conditioned space, everything, and you put it in a separate building without an ADU, they said it's approvable. So the real question is, what does adding a separate ADU do to make that space no longer approvable? And the only way you could get there, I think, is staff's view that, well, you got to look at this holistically. It's one building. And I don't think you do. The state law specifically defines an accessory dwelling structure as a residential structure that is used in connection with a single family dwelling. I think under the law, the text in context, and the state and the county adopts that same definition, you can have an ADU residential structure in a building that has another structure, and that structure can be accessory to the main dwelling. That's one way to look at it and get to the same point. My alternative was, if you indulge staff's position that you got to look at it holistically, it's one thing. Well, then staff agrees with me on this. You can have 900 square feet of usable space in your ADU and an unlimited amount of garage space. The board decided we're not going to put a limit on that. And so then if you look at this, what facts would you have to conclude that any of that space outside of the ADU is not part of a garage? Zero. The only evidence in the record is that all of the space outside of the designated ADU is garage space. And therefore, under staff's own position, looking at it holistically, you would have to approve it there because clear and objective standards, that's garage space. And so there's two ways to get to the same end. Both of them are the ADU is allowed under the current law.
So let me pull two things out of that response that relate to other questions I had. One is you've put a lot of weight onto the applicant's intention for how they're going to use the space. I take that at face value, especially if there's not any countervailing evidence about their intention. Land use approvals are run with the land and it's permanent. Do I need to grapple with what future owners who with an unknown intent might use that space and how that fits into your functionality analysis? Because it seems very focused on the initial occupier of the building as opposed to what someone else might do.
I think it's the same way you deal with and grapple with this similar situations in EFU land where you have to sign covenants, recorded covenants. So the county does that with other things like restrictions on remonstrating against farm activities. If you have a farm dwelling and you have to sign a covenant that you're not going to do some other stuff on it. There's all kinds of covenants that you have to sign in this county that go run with the land that you're not going to do something in the future. Unfortunately, I think that's the only thing we have, right? I mean, I can't, me nor you nor the county staff, nobody has the magic wand to say we're going to be able to control everybody, their intentions and their actions in the future. I mean, if that were the case, enforcement would be easy, but we don't have that.
And so maybe I didn't follow your earlier comments well, but is that a tool you think the county has in this case? Or you're suggesting that's a tool the county could create
Well,
if they went back and made legislative
No,
changes?
I think they have it now because the code and the statute says the county can put other restrictions and conditions on ADUs. Well, first of all, they may need to, going forward in other applications, do something, but in this case, not an issue. We're voluntarily offering that as a condition.
Okay.
My clients will sign a restrictive covenant that the only space that will ever be used in that building for living space is the 900 square feet of usable floor space currently designated on the plan.
Okay.
They're not just saying it. I mean, they really mean that, and they're willing to record something saying that. And I think that's about the only mechanism we have, the best mechanism we have in any county.
Thank you. I understand your argument about needed housing and the clear and objective standards. And my understanding is it's a pretty broad statute. It's housing, including needed housing. I do note though that the statutes do have separate sections for ADUs. So is there any authority about the ADUs specifically fall within the housing/needed housing construct? Or is your argument just based on the fact that it's housing related, therefore the clear and objective standards apply?
What I can tell you from my many years of experience, most recently in housing, is that ADUs have been approved and ordinances have been adopted because they are considered needed housing. And if you read I think it's the Rogue Valley Realtors case, the definition of needed housing is about as broad as any definition you'll ever find in the law. But we don't really need to get into, statutory construct. The county board acknowledged that this is a form of needed housing. And my legal analysis is if it's determined to be needed housing, then the statutes that apply to needed housing apply to needed housing, irrespective of whether it's an accessory needed housing or it's a main needed housing.
And then I think the last question I have is, I think your summary is there's no express prohibition on having an ADU in another building. I always start with kind of the textual argument. So I'm looking for the county's code. I wouldn't say it's circular, but defines structure, and then building is a structure. And you're sort of saying a structure is part of a building. You can have two structures inside of a building. So I guess I'm looking for some help on the text-based argument. Not that there's a limit on having an ADU in another building, but more that it is permissive to have an ADU in another building.
Well, if you look at 18-116-355, and this tracks state law, and this is what gives you the only clear and objective requirements on what an ADU can have. And so if you start in B and you go down 1 through 18, there is nothing there that prohibits an ADU in another structure. And the way I've always operated and understood the land use laws are that codes are permissive unless there's an express prohibition. So you do have some codes that will say, for example, in the county here, there's the one on the floodplain that specifically says prohibited uses. Well, if here, the only way to read this code, it's permissive. These are the clear and objective standards, and there's nothing here that says to an owner, you can only have an ADU if it's a standalone structure.
And then I think I thought you cited to something, or you were starting to language about building or portion thereove, but I
Yeah,
wasn't tracking where what the source of that was.
Well, that's context. So in 18-116-335, that's where the county makes this distinction, which is a little difficult to get your head around at first. So they say we're defining an ADU to be the entire accessory structure, including carports, decks, porches, and covers. So on the one hand, they define ADU broadly to be everything. I think it's everything that supports the living space, but it doesn't really say that. And then they go later and they go, but the 900 square foot limitation, we're going to incorporate that from state law, and that only applies to usable square feet. And so the county, instead of coming up with a new definition of usable floor area or usable, as the statute uses it, they went to their definition of floor area in their code. And the definition of floor area in the code talks about the area inclusive of walls, a horizontal space intended to be floored surface contained within a building or portion thereof. And so from that, I read it to say, well, the county code specifically allows you to have usable floor area in a portion of a building. Otherwise, that language wouldn't be there. They would say floored space contained in a building. But clearly, they're saying you can have separate usable floor area in a building, and by necessary implication, that building can have other areas because you can have usable floor area in only a portion of it. And then you could have non-usable floor area in another area. And so that, I think it's just further context for my position that 18-116-355 lists the criteria. It doesn't say you can't put it in another building. I think the state law also kind of helps me there because the state law does define an ADU separately than an accessory structure. It's a residential structure. Now, together, I think you read those and say, well, if it's a separate residential structure and there's nothing that prohibits you from putting it in a building, you have to be able to have two structures in the same building. One, this really specific thing, it's a residential ADU structure. It can only have 900 usable floor space in that portion of the building. That's clear. But then you've got this other stuff that's accessory to another part of the property, and that's not part of the ADU at all. That's just accessory to the main building. And so that's how I get there from the text and context.
Thank you. I think that's it. I was going to ask if the CCRs are in the record. It sounds like those are.
I forgot to send them yesterday, but I did find them this morning and just shot them over. I think they're, you heard Ms. Schilling talk about it. It's everything she said is in there. It really goes to the dormer. My clients really didn't have the opportunity to put up a square box. They had to do it consistent with the neighborhood.
Okay. I'll have staff come up and then of course I'll turn it back to you if you need to.
Good afternoon, Hearings Officer Will Groves, your planning manager. The comments I make, I want to be held lightly. These are me sort of thinking about this out loud. This is a matter of first impression for us. Of course, the state statute is relatively new. The board's implementation is relatively new. If you think about the big picture, you see a state statute that's trying to limit the size of these structures. And we definitely have run into a variety of proposals, although, it's clear that this one is not that, where people are trying to bowl through the 900 square feet of the ADU by having, attached space. So we've thought as unproblematic if they say you had what we call a barn dominium, that someone wanted to build an ADU in a barn, and that the rest of it was undifferentiated garage or barn space. We thought of that as unproblematic. What we've run into is where people immediately to and accessible from the ADU have a door through to a game room or, a personal use office. And so it really feels like that the ADU 900 square feet is being bypassed in that way. So we've got a question here, I think, which is how do we differentiate those, or do we have any obligation to differentiate them whatsoever? If you had in the example that I cite as what seems to be a foul, if you had a 900 square foot ADU and then air gapped it to another structure that, was a residential accessory structure that had a personal use office in it, a half bath, we would think of that as unproblematic. So I think the applicants have zoomed in on this question about, what it means for this use that would be allowed otherwise to be attached. And I think we're running into problems of definitions and code from different times and different purposes. And you run into this all the time. We made a good faith effort when writing this to try to plug it into our code, but this wasn't all written at the same time and masterminded. So the floor area definition comes from a different time. And some of our other patterns and practices came from a pre-ADU time. So just acknowledging that, you're trying to make sense out of something that wasn't necessarily built to make sense. And I appreciate that effort. I think the first constraint, is does this pass through RS 215 requirements for an ADU? I think it's, we have a statutory sideboards, and it may be that this passes through that gate. When the county adopted code, there was really no significant challenge to that code. And we presume that it is what we adopted is facially compatible with that and isn't introducing new uses or somehow allowing ADUs to wander outside of those statutory sideboards. I want to talk a little bit about clear and objective. I don't know if the applicant's making this argument, and I've thought about before but haven't resolved this question of what happens when you attach something to clear and objective housing. So let's say that I have a house and now I've built it, it's say residential over commercial. And because the residential is over the commercial, the only way it can be built is if the commercial is built. Does therefore the commercial development have to be clear and objective? And I think there's a parallel here, which is the question, if in fact what's happening here in the same structure is a residential accessory use to the main dwelling attached to an ADU, how do we parse it? I'm worried that you could attach a dwelling to anything and then force clear and objective standards on basically any use from that angle. And I'm not sure if there's been case law. I know certainly those our UGB, our city partners and within UGBs have been subject to this clear and objective case law for some time requirements. It's relatively new to counties since 2017. This came up in a case in Washington County, so and then elaborated in the legislature. There may be case law that gives us some sort of understanding of that. Again, the concern here, we talked about the neighboring property, the applicant mentioned that, and at a quick review of that floor plan, what you have is you have kind of the barn dominium format. You've got an ADU and what's otherwise undifferentiated garage space that couldn't really be plausibly put to any use other than garage. To the extent, let's talk about covenants. We use covenants regularly. We're not the we can't detect all, we're not trying to prevent all possible illegal uses of a structure by design. Certainly you could build a variety of things that look lawful at their outset and they could be put to unlawful uses. So if this is otherwise compliant with the code, we have no objections to a covenant as a way to deal with this issue. And this may coming to another point that I was thinking about, which was, we're going to, at some point, staff, is going to, assuming there's an approval here, will rely heavily on your thinking as we try to differentiate other similar proposals. And so there'll be a question, which is, do we really have no ability to issue, to use discretion, as people attach things to ADUs? That doesn't seem like the right answer. So it sounds like staff will have to use some sort of discretion as we look to things that are attached to these ADUs in terms of if they're approvable or not. It seems like an owner declaration in combination with a covenant would likely be sufficient. We allow other things that could be plainly put to illegal uses to be approved in that combination of declaration plus covenant. So that may be a way to solve that.
Do you have examples of what the owner declaration?
Yeah, so with some detached accessory buildings, we regularly see those that they'll have a half bath in it, let's say I wanted to have a pottery workshop that starts looking pretty close to a kitchen, and then you have a personal use office, and all of a sudden it's something very livable. And so we can include in the record an example of the type of covenant. It basically says, you said you were going to do X with this. Please understand that it can't be a standalone dwelling unless and until necessary permits are obtained. We want to make sure that this declaration, or the recording, that we don't have to extinguish it. We want it to have a pass through that says, look, in the future, if you get some sort of permits that are otherwise lawful, this recording doesn't preclude that. So I think we could do something parallel here if you wanted to go in that direction, which would say, that these areas, per Exhibit A attached to this recording, the ADU is shown in, the hatched area, and non-ADUs are shown in those hatched areas. The non-hatched areas or the non-ADU areas cannot and will not be used, as a part of the ADU as living space. This is a use allowed accessory to the primary residential use, and storage use of that shall be, exclusively for the benefit of the primary residence unless and until permits are obtained otherwise. Something like that but we can give you an example that would get a long way there.
Since we're just talking about this matter of first impression, then
Yeah.
if we were in a different situation and you took out this garage and you were just building an ADU, but then it sounds like the code is written in a way that the ADU itself can have a garage and that it's, according to the applicant, an unlimited amount. Anytime I hear words like that, my ears go up. Oh, unlimited sounds extreme, but it could also be exactly what the code says. So do you have a take on that?
Some zones have lot coverages, and you'd run up against that eventually. But, this question was before the board, and Planner House included in the record the board's deliberation matrix. So you can kind of see the options that were before them. And there was a recognition that, an ADU, at least to the board's thinking, and I'm paraphrasing here, is that, an ADU needs a garage. We initially said, well, what if it was unconditioned space? And then people noted that, it gets real cold in Oregon and frequently conditioned space garages are a regular thing. And so, they carved out these exemptions for garages, carports, porches to try to make these structures more usable by people. The notion, what we get out of statute at the ORS 215 level is we get the phrase usable floor area that's completely undefined. And so you can see our board struggling with what that entails. And they settle somewhere in, conditioned floor area within the dwelling, but they never exactly say that. They've allowed garages to be tacked on in a way that, again, we presume to be compliant with the statutory framework, but it's not spelled out.
Thank you. I don't have any other questions for staff. Mr. Koback, if you would like to, yeah, you can come up.
Thank you again, Chris Koback, for the applicants. Really appreciate Mr. Grove's comments, as always, very insightful. And I think he kind of is underscoring what I'm saying, which is state law comes down. This happens a lot. We did it with the middle housing and then the middle housing land division. The statutes come down and then the cities and counties have to deal with it, right? And sometimes the code gets written quicker than it maybe staff would like, and there's things that have to happen. But to deal with it on a case-by-case basis, I think is more problematic than treating it like a legislative fix. Because, for example, Mr. Groves noted that there might be some differences on how the neighbor who's got an ADU in a garage labeled things on his plans. Well, is it really going to come down to how creative you are in labeling your plans? That's kind of what we're going to get into if we do this on a case-by-case basis and say, well, we're going to allow it here and we're not going to allow it here. That's why I think for now, if there's no prohibition and the clear and objective standards, to the extent they have them, allow this, it has to be allowed here, and then there can be a legislative fix. And for the short term on this one, I appreciate Mr. Grove's comments on the covenant. I know we can come up with a covenant that would protect the county to the extent it's protected in any other similar situation. Like I said, you've heard my clients. They're very sincere people. They don't want to game the system. That was never their intent. They'll do whatever reasonable conditions the county wants to make sure that the county has assurance that this is going to be what it's going to be. It's going to be a really, really cool garage for showing off cars and having people enjoy that. And so I think that's really all I have to say. Again, I do want to have the 777. I want to give you that decision and maybe a couple other things, and maybe staff can present that form of covenant, and I'd like to see that too.
Yeah.
I know applicant needs final word here. Is it okay if I introduce something again with the idea?
I don't.
So I just wanted to note something that was surprising to us is that we this question about ADUs effectively as a duplex in a single family dwelling. I think this is an adjacent topic that's worth thinking about and may be helpful to your argument, which is that, we had presumed that because it talked about, measurement from exterior walls, some of the other provisions in both state statute and our local implementation, that you couldn't effectively make a dwelling ADU duplex. You couldn't carve out an area that was in a single structure and had a primary residential dwelling and an ADU. And we ended up having some discussions with one of the sponsors of that bill, Senator Dembro, and he made it clear that at least his understanding was that that was to be allowed. So I think you'll find that was given the language that was implemented in statute and locally, that was confusing to us. But certainly we weren't in the business of getting in way of either needed housing opportunities, or certainly legislative intent. So one of the things that we've run into about these kind of conjoined structures, at least that part came out of a correspondence that we had with the senator about the intent there.
Yeah, and I appreciate that, Mr. Gross. That was kind of my understanding. ADUs, there's ADUs that are called, and I've helped people get them approved, like mother-in-laws. You got a walkout basement, you put a separate dwelling unit there, and it can be approved in most cities as a accessory dwelling unit. And I understood that the county, the state law allowing ADUs in counties was going to operate the exact same way. And so my point is, if you can have an ADU mother-in-law in a basement of a house, walk-out house, it's sharing space with the rest of the house. You could never approve that if you find that you can't approve my clients, because they're the same situation.
Thank you for bringing up that issue. And so, well, are you done with your?
Yes.
Okay. I think it would be helpful to me if staff and the applicant address that, because I think in the kind of the colloquial use of the word ADU, I think a lot of jurisdictions do that. It can be a separate structure. It can be a mother-in-law suite type thing in the basement. But every jurisdiction is different. So the question is either, is it mandated to be that way by the state? And if whether or not it is, what does the county code actually say? That was behind my questions to you earlier about, I get that the county code doesn't appear to expressly prohibit it, but does that mean then therefore it is allowed? So it would be helpful to have any information about that. Also, it sounds like you are both on the same page of a sort of this covenant idea and the declaration. It'd be super helpful if you submitted something jointly, so I don't have to wonder if there's counter arguments. Obviously, you don't have to, and if you can't come to that, but it sounds like you're talking about the very same thing. So to the extent you can offer something that works for both of you, I think that would be super helpful.
I appreciate that suggestion.
Other than that, I think the 777 period is fine. I always am curious in December when people ask for that, if that actually works with your schedule, if you want it to be different around the holidays.
That I've been known to agree and then go home and be told that I'm stupid by my family.
I've been in that position.
Yeah. So do you guys have a calendar?
Yeah, the second 7 would fall on Christmas Day.
But we would, so at least.
It would.
Well, I don't want to work that
Which
way.
usually means New Year's is.
I have children coming in who don't visit very often.
As the applicant, it's whatever you agree to.
I think the first, do you guys, can you get everything in the first 7 days that you want? We can too, but if we could extend maybe the second period to 14 days, does that work for you, Bill?
Oh.
Why don't, I would propose that to 7, 14, and 7.
Okay. Yep. That's why I asked.
Thank you. You saved me from getting yelled at.
All right. I think that's it. I don't think anyone else has signed up to testify since we've been in here. So we will keep the record open. Well, let me say it first and then I'll turn it over to you. But I'm going to approve a 7-day period. And then Ms. House, I think, is going to have additional instructions based around those dates for how the information can be submitted.
Yeah, and I'm gonna just pull up my calendar so I can see the dates on the record at today's hearing. So first 7 period for new evidence will end at 4 p.m. on December 18th. Then we have 14 days from that, which would fall on the 1st, though, which we're closed for business that day. So maybe it needs to be a 7:15.
That makes sense to me.
And 7, does that work for the applicant?
Yes, thank you.
Okay. So then that means the rebuttal deadline would end on Friday, January the 2nd, 2026. And then the final legal argument by the applicant only would be Friday, January 9th at 4 p.m. Does that match? what you-
It does.
Okay.
Do you have any other instructions?
Yeah, just a few kind of housekeeping things. So everything should be submitted to me. If you want to drop it off, that's fine too. But if you're submitting anything electronically, please email that to me. It's caroline.house@deschutes.org. The other thing to keep in mind is we do not retrieve information from a website link or cloud storage services. So send us the actual photos or images that you're trying to enter into the record. And don't wait till the 4 p.m. deadline to submit things because sometimes it takes a while to get through. And but 4 p.m. is the hard deadline, and that must be received by the county server at that time.
I don't need to, I usually say this for the benefit of everyone. Mr. Kovac already knows this, but the open record period will be for new evidence. The rebuttal period will be for anything responding to the new evidence. And then the applicant's final legal argument just for the applicant and no new evidence. So we've got the schedule. With that, we will conclude this hearing. It is, I can't see my glasses. It's 2:05. And we'll go off the record. Thanks.